let's start with our thoughts on Diddy's sentencing last week. So, Arthur, you like the sentence? 50 months? You're the criminal defense lawyer amongst us. Matt and I are former prosecutors. I assume you wanted him to walk free and get a bronze medal or something. What's going on?
I was, how are you, sir? I was very, I should say, sirs. I was very, look, I know many of the defense attorneys on this team here. I think there was 8 in total. So, of course, as being their buddy, I was rooting for them. They did great. I mean, let's be realistic. It's the Southern District of New York. That's where I've been practicing for quite some time. It's a very, very tough place for a defendant and a defense attorney. Many of those judges are former SDNY prosecutors. They lean heavily in that direction. So when you get handed a client, you get retained by a client who's facing life in prison, and at the end of the whole thing, they're going to have to do probably another 24 to 29 months of incarceration in the SDNY. That is a win. So, I mean, their sentencing was a real production. I don't think I know of or have ever been involved. I know I've never been involved with the sentencing that started at 10 a.m. and ended at, I think it was 4:40 when the judge gave his decision. I don't know how much influence their efforts made, although the judge did say, I'm cognizant of the guidelines here, and I'm not sure why I should stray from them. But I don't know if the judge, who's a very smart guy, clerked on the Supreme Court of the United States of America, whether he was playing a little bit. Look, when you have a case of this magnitude regarding the media, there's a lot of gamesmanship. There's a lot of playing to the cameras, a lot of playing to society. And that is one of the things the judge had to take into consideration in the sentencing when general deterrence. I mean, by law, he's got to take into account general deterrence. And when he said, I believe a significant jail sentence, I think it was a significant period of incarceration is necessary here. I did not expect him to say 50 months. I was expecting, 100 months, 120 months, 10 years, 8 years, 7 years. But I will say, in my own defense, consistently from the day of conviction until the morning of sentencing, when everyone on the planet Earth asked me what I thought, I said it's plus or minus 5. I said he could go as low as 4 or as high as 6, but I think that's the range where he'll wind up. And he went on the lower end of that range. So no matter how the defense attorneys say that they're disappointed and it was a miscarriage and it was the judge was the 13th juror, from a very realistic and objective point of view, the defense team did a great job.
Well, Arthur, you teed this up nicely. Before I go to Matt, I want to play clip 1 where that defense lawyer, Mark Agnifilo, is talking about the judge as a 13th juror and saying he will appeal. Let's play that clip.
We are planning to appeal. We think we have strong bases to appeal. The strongest basis is that the jury reached a verdict on coercion. It found there was not coercion. And I think the judge said coercion today as a basis for a sentence at least a dozen times. We think that that is unconstitutional. What we feel happened today was that the judge acted as a 13th juror, yes, one that we did not choose, and that he second-guessed the jury's verdict.
All right. Now, that guy on his right, on our left, looked a little bit like you, Matt Murphy. Do you have a doppelganger is my first question. And secondly, what do you think about the verdict here, the penalty?
Well, Arthur's right. This was a huge win for the defense. Remember, he was facing life, and they came back with these 2 Mann Act violations. The judge actually came in and he said the range was 70 months plus. So he did depart from the sentencing guidelines. He departed downward, which I think is going to insulate this on appeal in a big way. There was a law that came in, essentially, that federal judges cannot sentence on what's known as acquitted conduct. But he didn't really do that. He based it on violence that he heard related to various things. Like, they didn't convict on the RICO allegations that had things like arson or the video of Cassie Ventura's beating in the hotel that we've all seen a million times. But the court, I think, can still consider that as circumstances surrounding the offense. That's the ruling that the judge made. That's essentially what they're going to challenge on appeal. I I don't think that's going to go anywhere. I think that, and I wanted to get Art's thoughts on this. I did a little math on this. He's going to be eligible for the RDAP program. That's a residential treatment program. That knocks 12 months off your sentence, I think, in most cases, and he'll be eligible for a halfway house 6 months prior to the termination of his sentence. He's already got over 13 months in. So by my calculations, he's only looking at about 18, 19 more months, right, before he's eligible for transition into a halfway house. And any appellate process that they've just kind of boldly announced on the courthouse steps very dramatically isn't even going to be in its teenage years by the time he's already out, is the way I see it. You can still run that, I suppose, but I just don't see that getting any traction, guys.
Let's play it
Those are
out.
my thoughts.
I think your calculations are pretty correct. I mean, we will guesstimate a little bit. It depends whether he gets in a fight when he's in prison or anything like that, but more or less you're on target. But if you play it out, Dave, so hypothetically, he wins. Now, it would only be if he won the appeal. It would only be a retrial on the Mann Act, right? He's already been acquitted. But, you never know what could happen, right? He could go in front of a different judge who then sentences him in a different way, although you're not supposed to be penalized. But if new facts or new circumstances came up. So I get the fact that they got to say they're going to appeal. And I'm assuming they are going to appeal. But Matt's right. I mean, it's even if they expedite the whole thing and they say, oh, yep, it's reversed and he should be let go, it's probably going to be a matter of maybe many weeks or a couple of months. He didn't get sentenced to 10, 15 years. He got sentenced to 50 months. I will tell you guys, I was literally walking to the cameras because I did a lot of media at the sentencing. But I was listening, I was reading actually the New York Times, and I think it was CNN, they were live streaming from the courtroom exactly what was being said. And, when the judge said things like, I am taking into consideration all of your good deeds. However, whenever you hear a federal judge in sentencing say, however, you're like, oh boy, here it comes. I cannot ignore the bad things that came out in this trial. And he is a human being, and he did see a grown man beating the hell out of a defenseless woman. And to say that doesn't play a little bit of a role means, you think the judge is a robot. But then when I heard 50 months, I was like, whoa. I mean, he gave him the maximum fine, which was, for him, it's probably like Matt giving me a nickel. But, it's overall, he's done. I'm sure. I know the defense was looking to go to have a celebratory meal. And I was texting them saying, you should still have that celebratory meal. Like, you guys crushed it. They wanted to have it with their client. And the judge said what I had been saying for a while. Prosecutor asking for 11 years was ridiculous and out of the realm of reasonableness. But the defense asking for time served, which was 14 months, basically, when you factor in his good time behavior, was also ridiculous. And the judge, he didn't go through the middle. He went closer to the defense request. And as someone who's been in the Southern District of New York for decades now, that doesn't happen too often. So hats off.
Art, I think it is the Goldilocks approach. Not too little, not too much. I mean, after all, if he had gone higher, which he could have, then it would have given the defense more grounds for appeal. So it's more likely he stays behind bars because of that sentence. That's Matt Murphy's point. Plus, there is the possibility of a Trump pardon.